Good morning, good afternoon, and good evening, everybody, and welcome to the latest edition in this year's Administrative Law and Governance Colloquium on the Legitimacy of the State. I'm Paul Daly, the University Research Chair in Administrative Law and Governance at the University of Ottawa. The topic this year for the colloquium is, as I say, the legitimacy of the state. And that's because the legitimacy of contemporary liberal democratic states is in a state of flux. Managing the effects of globalization, responding to the COVID-19 pandemic, and fighting escalating inflation and occasionally bank collapses have prompted serious questions about public administration in the global north. These pressing issues have shone a spotlight on difficult areas for liberal democracies, which have struggled in recent decades to reconcile popular desires with the need for effective governance. In this year's colloquium, speakers will address and have addressed challenges to legitimacy by focusing on a range of institutions. We've had Margaret Cohn on the executive branch, Joseph Heath on the civil service, Liz Fisher and Sid Shapiro on administrative agencies, and today we have Robert Thomas on immigration. The overall goal is to outline contemporary legitimacy challenges and likely responses. Today's guest is Professor Robert Thomas, Professor of Public Law at the University of Manchester in the United Kingdom. His research interests include law and administrative organizations, administrative tribunals and other redress mechanisms, judicial review and administrative rulemaking, administrative law and institutional constitutional design, asylum and immigration law, and administrative justice. 2003-2004, he acted as specialist advisor to the House of Commons Constitutional Affairs Select Committees with regard to the following inquiries: immigration and asylum, the government's proposed changes to publicly funded immigration and asylum work, and asylum and immigration appeals. He is a leading expert in administrative justice, administrative law, with a particular focus on immigration. And I've asked him to speak to us about his recent book, Administrative Law in Action, which focuses on the immigration system in the United Kingdom. Robert, thank you very much for joining me. It's good to see you.
Thank you very much, Paul. Great to be here, and very good to be here. See you again as well.
And so, well, why don't you kick us off by telling us about this project and what got you interested in it, its genesis, and what you were hoping to achieve?
Yeah, that's a good question. So I'm an administrative lawyer, as you've said, and I've spent a lot of time looking at how administrative law works in practice, and in particular about judicial review and tribunals and those typical types of remedies. And I've done empirical research in this area. So after a while, I was sort of like thinking, well, I've done a lot of work on judicial review and tribunals and remedies, but what actually about government itself and about how it operates? So it was about 3 years ago now, with lockdowns and so on, that really gave me the opportunity to work on something that I'd been thinking about doing, but I'd been a bit uncertain about how actually to go about it, because it involved like looking at administration itself and government and the work of a particular government body. So I thought I'd give it a go, and the result was the book that I did. And it's basically like a detailed case study of the immigration department in the UK, and about what it does and how it does it and how it works, and more often than not how it doesn't work, because all government bodies have real challenges, real performance and operational challenges. So I mean, I'd long wanted to like approach administrative law from that angle, and to look at how administrative law actually works in practice, the challenges that face government, and to bring together all of the evidence. And that can be a bit difficult, because we don't normally have direct access to government. It's quite difficult to find out, what's happening within government. So that was my my task that I set myself, and it really does like play into the theme of your colloquium about legitimacy and the challenges that government bodies face. And legitimacy, I think, is quite a problematic concept, and how you actually go about assessing legitimacy. So that was in the background, but and I'll speak more about that. But the real impetus for the book was to look at, well, what does government do? How does it do it? And how government uses law to administer its policies, to make and implement policies, and the actual, functions that government does, like making rules, making decisions on people's immigration claims, enforcement, handling challenges against decisions, and the performance of that particular government department, as they're called in the UK. Is called the Home Office, that is responsible for administration. So that was like the background of the project. And so as I've said, the book goes through looking in detail about how the government body is organized, how it operates, and the tasks that it performs. And the core of it, I think, is it requires like a real change of mindset about how you understand administrative law, because there's different ways of looking at it, that particular topic. And the conventional approach is to look at the courts, and and the doctrines and principles of judicial review. That's very important. At the same time, there's this much like wider background about the operation of government, and that the reality is that the vast majority of laws that we actually have, they're rules, regulations, and legislation. Once you look at government in that way, and you look at administrative law in that way, it's very, very diverse. So what happens in one context is very different from what happens in other, like, policy contexts.
Can I
So,
just
yeah, go.
rudely interrupt you there, because you've touched on something that I find very interesting, and I think you explain it very well in your book. You distinguish between the legality model of administrative law and the governance model. And as you say, many of us, and I'm probably particularly guilty of this myself, are interested in administrative law as mostly being what the courts do. But your book's not about that. It's not about what the courts do. It's about the blood and guts of the system. So it's about governance rather than legality.
Yeah. I mean, I'm very much, when it comes to method, I'm very much a pluralist, and there are different ways, and I think each way of approaching each method has its pros and cons, advantages and disadvantages. So I think it's very valuable to have a plurality of different approaches. Let a thousand flowers bloom would be my approach. And I think, like, one of the issues I've got with judicial review focus, or a court-centered approach, I think it ultimately, it's very important to look at the doctrines and principles. At the same time, there's other remedies that people have against government. I think that would be one point. And I think the other point would be, well, actually, if you look, for instance, at judicial review, I can only speak about my own jurisdiction in the UK. Each year, government takes millions of decisions and actions and so on. But the actual number of cases through judicial review that would end up in a substantive hearing would be about 200 per year. So, the courts are certainly very important, and they're key. At the same time, they're not everything. And that was really what was motivating me. I mean, the terms that you referred to, legality, a legality model versus a governance model. I think one of the aspects of focusing on legality is it's looking at the outer limits, the legal outer limits of what government can and cannot do lawfully. But within those limits, of course, there's a whole range of different actions and decisions that government takes. And this is the focus of government is about effectiveness, about making and implementing policy, getting things done, administering policy, and setting up systems, administrative processes and systems in order to implement policy. So that was my approach. And I can give some examples of this. I mean, very often government, sometimes its policies are successful, other times there are real failures by government. I mean, government departments can really mess up big time. And one of those main areas is actually immigration, amongst others. The other point I'd like to introduce is I've been quite interested about how government is organized and also the institutional behaviors of government, because we've got to recognize that government is this, we talk about government in the abstract. Of course, it's made up of many departments or boards and tribunals and so on. So you really have to look, well, what's the background? What's the broader context in which government is operating? What are the social, economic, and political forces? And then how do those forces, how are they absorbed by government? And, what are the tasks that government has to do? And very often, the tasks of government are just incredibly challenging. Bearing in mind that government's got limited resources, there are complex systems of organization and delivery, and the challenges that government has. So this is not to excuse government failures in any way, but it's just to say, right, we have these set of institutions. Let's look at what they do, how they do it, and how successfully they perform their tasks. And that really feeds into the wider discussion about legitimacy. So
one of the striking things I thought in your book is the description of the institutional structure of the Home Office and how it changed, and how politicians would make changes to the structure in response to short-term political concerns. And in the end, these institutional changes didn't make much difference. I mean, whether you had a government department or a next steps agency within the department or some sort of autonomous units in the department. And this is a story, by the way, which I think is true of other jurisdictions as well. I mean, in Canada, we have all sorts of institutional structures created for all sorts of reasons at different times. But often the underlying policy is challenging, it's complex, and there's really no getting around it.
Yeah, I think that's right. I mean, there's a real tension between politics and administration, and that it's almost like those tensions are irresolvable about the short-term political interests of politicians, what they want to achieve, why, for votes, for good headlines, because of the political pressures they're in, because they work within electoral cycles. On the other hand, there's the administrative system and its performance, and political interventions in the operation of administration. They can be significantly dysfunctional, precisely because of the factors that motivate politicians. But on the other hand, like both of these forces, politics and administration, that they must be two parts of what make up legitimacy. Because in a democracy, we would say, well, the people elect governments, we have general elections, and we elect representatives to hold the politicians, ministers and so on to account. And we have the permanent civil service, who are governed by their, values and codes. They serve the government in power. And there's a real tension there, and I think it comes across quite well in contexts like immigration, where politicians will be motivated to intervene, to restructure, to be seen to be doing something. And very often these changes, they have longer term dysfunctional consequences in terms of administering the system and getting things done. And that also extends to a major force that bears down upon government, which is, how much does government give a body like the Immigration Department? How much does it give it in terms of resources to do its job? Because all government depends really upon, public services, government departments being effectively resourced, and political factors will come into that again. Immigration in the UK, that if politicians, if government ministers, if they give a lot of money to the Immigration Department, that means less for elsewhere. But it's necessary in order to administer the system and have good quality administration. So there are some really, looking at this book, it sort of forced me to face up to some really intractable issues. And I think it goes straight to the, problematic concept of what is legitimacy. And it's a very problematic thing to assess. So looking at how government departments actually work in practice, what they do, how good are their processes for making policy, and how effectively can they make policy, and do they actually possess the competence and knowledge to make policy effectively? These are quite important aspects of administrative law in practice.
And the audience is on tenterhooks. How does the how does the UK Immigration Department score out of 10 on that scale?
Yeah. I think the best example that I can give, and it's the most notorious example, has been what's called the hostile immigration environment that was set up about a decade ago by the Conservative government. No one really knows. I'll just set the scene. No one really knows how many people there are in the UK who don't have immigration status to be here.
I guess before we go any further, I guess just to tee this up for a Canadian audience in particular, there's no real political pressure around immigration in Canada. Certainly not on the scale in the UK. There are pockets of it here and there in various. So the French language immigration in Quebec is an issue. But in general, Canadian politicians, and I would say there's a cross-party consensus on this, are in favor of immigration and having an inviting and welcoming system for people to come to Canada, in part because it's essential for economic growth. Now in the UK, it's quite different, isn't it?
I mean, it did used to be fairly similar to Canada, but it's become a very hot political issue over the last 2 decades. So yeah, I mean, I think that illustrates really about the effect of politics and political forces on the work of government. So the big push was to make life uncomfortable for people without immigration status. So someone in the UK without immigration status, they would have difficulty getting a job, they'd have difficulty renting property, accessing benefits, healthcare, bank account, and so on. So that was, I guess,
we should tell people, I mean, that there are statutory requirements that say you have to provide proof of your right to reside in the UK in order to open a bank account, get a driver's license, or even rent a property.
in a sense, like the administrative system traditionally of immigration, it's like immigration control at the border. You know, if you enter a country, you show your documents. If you've got, you know, permission to go in, you go in, and then that's it. There's no other checks. So the effect of this was to like internalize border control. So, you know, if I you know, act as an external examiner for another university, I've got to take my passport along to prove that I am who I am, which was really unprecedented change. So this was the big push by the government that's still in power, and this went through. It was enacted into legislation through the Immigration Acts and so on. And there was a big flaw in the whole policy, though, because after the Second World War, about 500,000 people largely from the Commonwealth countries, in particular the Commonwealth Caribbean, like countries like Jamaica and other islands in the Caribbean, but also people from Canada, Australia, and African countries, they'd entered the UK in the 1950s, 1960s. They'd been allowed in, they had the right to enter, and they were later given permanent right of abode in the UK. And this was called the Windrush generation, because many of these people came over on the Windrush boat in 1948 from the Commonwealth Caribbean. That was in the 1960s, 1970s. And then decades later, the hostile environment was introduced. Now, when these people came over, they were not given an official immigration document to prove their status. And it was about 500,000 people. So the hostile environment was devised in the 2010s. And by that stage, the immigration department had completely forgotten about these people. They're called the Windrush generation. They're completely forgotten about it. So the hostile environment was then applied against these people. And some of them, well, they lost their jobs, they lost benefits, couldn't access healthcare. You know, if they were renting a property, some of them were kicked out. Some people were put in immigration detention. They were put in. Sorry, they were put in immigration detention. Some of them were removed from the country. And this all came about. This came to light in about 2018. It was a big scandal, a really significant failure by the Home Office. You know, a real institutional, organizational failure. And the failures go right back to what I've been talking about in terms of the importance of policy making. Because when the Home Office had made the policy, it had completely forgotten about the Windrush people. There hadn't been enough challenge within the Home Office when it had been making the policy. It was a very top-down approach with ministers, exactly what we were just saying about politicians, the ministers in control. The Home Office had actually been explicitly warned about this, that it would penalise people who had immigration status, who were in the country lawfully, but did not have the documents to prove it. And the Home Office had been warned about this, and it ignored those warnings. And there were a whole range of other failures as well. And it was, you know, it was a real chronic, appalling, terrible failure. You know, just a real failure that harmed many people. And that's really led to lots of calls to reform the Home Office and to improve it. Now, throughout the whole course of this,
sorry, can I? Yeah,
go ahead.
You were just getting revved up to go on another point, but you said something that I that I did want to press you on, well, not press you, but just
Yeah.
have you elaborate on a little bit, because we had Professor Joseph Heath last week, who was talking about the civil service and how the civil service in a Westminster democracy is a very important institution and has internalized in many ways some of the precepts of liberal democracy, which justifies civil servants in pushing back sometimes against ministers or political advisors who are proposing policies. And what you're saying here is that there probably wasn't enough pushback or challenge from within the Home Office, because the policy was imposed top down. The minister and the minister's advisors said, we want this, we want the hostile environment. This is what's going to work for us politically. This is going to achieve our and it's going to achieve our policy goal of making life unpleasant for people who are here without status. But because it was implemented top down and there wasn't any scope for challenge, that led to problems. How do you solve a problem like that? How do you solve a problem of an institutional culture in a government department which involves civil servants who are unable to push back against a minister and their advisors?
I think this is an incredibly difficult challenge, actually, because many of the problems, particularly like in the administrative justice context, when you really dig deep down into them, there are like underlying problems of administrative culture, and a culture within a government body can be very, very persistent and difficult to change. If you think, for instance, of aggressive policing, or other, like, public bodies where where there are problems, trying to change a culture, I think, is very, very difficult indeed. I mean, there was a formal report into Windrush that made a whole load of recommendations, and the issue then becomes, well, is the government's acceptance of those recommendations, is it just a tick box process? To what extent is there actual substantive change? This is very, very difficult indeed. I mean, the knee-jerk reaction would be to say, okay, let's change this organization, give it a new title, but you can put lipstick on a pig, but it's still a pig. And I think that is very, very challenging indeed. I mean, ultimately, change it can be prompted by external forces and parliamentary select committees and external reviews, but it's got to come from within government. And part of the challenge is, well, if you look at, well, what is the actual function that government is pursuing, and each area of government has got real tensions within it. If you look at immigration, on the one hand, the country is going to welcome immigrants. On the other hand, there's a need to to enforce and compliance as well, and that's really where those cultural issues sort of come about.
And I guess at the risk of circling back over territory you've already covered, I mean, I guess when we're talking about internal culture in government departments, that's where the value of focusing on governance rather than legality is really felt, because judicial review and the courts, they're not going to come to the rescue of the Windrush generation or people like them.
Well, I mean, I think I largely agree with that. At the same time, I mean, I've got a chapter on judicial review in the book, and I think one of the real values of judicial review is articulating norms and standards, and having like an authoritative statement, for instance. So, procedural fairness, the court's ruling against the abuse of power. These are like important normative standards to guide, and they provide a very important reference point. At the same time, judicial rulings can have very significant impacts upon government. There was a big ruling to say that the what was called the detained asylum fast track procedure was systemically unlawful. And that was a ruling by the Court of Appeal in about 2015. And that had very, very significant impacts on how asylum cases were, were processed. So I think judicial review certainly has a place, but it's not the only form of scrutiny. There are other forms of scrutiny as well that articulate different norms, like, for instance, parliamentary select committees and what in the UK is called the National Audit Office. That provides a very important role in how government spends money, how it manages and implements policy and public services. So that's like an equally important role. But ultimately, I mean, this is if you dig deep down into administrative law, government itself has to have an internal acceptance that it has to abide by certain values, one of them being lawfulness and procedural fairness and good quality policy making. So ultimately, you can have external actors telling government do this, do that, but if government doesn't internalize those values, then they're unlikely really to get a hold. So that's really, I think, is pretty much at the core. And this is so difficult because look at the size of courts. How many courts are there? How many other external scrutiny bodies? These are relatively small bodies compared to government. The Home Office, the Immigration Department in the UK, it employs about 38,000 people. That's massively bigger than the courts and tribunals and other oversight bodies. So government has to internalize these values, and I know that is much easier said than done, because there will always be failures, there will always be shortcomings. So this is part of like an ongoing process. And it also, incidentally, related to the courts, the challenges for the courts in immigration are different from the challenges faced in judicial review of a regulatory body or healthcare or anything else. So it really does help to situate what the courts are doing in context, because there are common themes there. There are overarching principles, but how they're applied is very often context dependent.
I should say, Robert and I, folks, can talk for hours if we're allowed. If you have questions for Robert, pop them in the Q&A box, and I'll send them on to Robert for answering. Just following up on your response to that last question, your chapter on judicial review is very good, as are all the chapters, Robert. And it is a useful study of how judicial review can be helpful in actually helping, assisting in a way the implementation of policy by making sure that things are being done in a procedurally fair and rational manner. It actually can help. And I thought the cases that you describe on systemic unfairness were particularly interesting. But after your book came out, the UK Supreme Court handed down a decision on systemic unfairness and the review of policies of soft law, which tried, I think it's fair to say, attempted to narrow the scope of judicial review for systemic unfairness. And I wasn't familiar with the details of all of these immigration challenges. You laid out a very strong case, I think, for the courts to take a more robust view of systemic unfairness, because it can actually be helpful for them to intervene in those instances. So I guess I'm wondering if you have any thoughts on the UK Supreme Court's turn away from systemic unfairness.
I mean, the way I read it is what the Supreme Court is done. I mean, it's very subtle, I think, but I think the implications are quite clear that it's saying that the lower courts, the High Court and the Court of Appeal, they need to be not pulled into, towed into line, not pulled back massively, but enough of that is the sort of the overall the message. I think it's a mistake, really, because I've read all of the systemic challenges, and there was quite a big systemic challenge about prisoners and legal aid and adjudication hearings in prisons. Well, look at the similarities there between immigrants, asylum seekers on the one hand and prisoners on the other. I mean, these are two, in the UK, two, generally speaking, two relatively powerless cohorts of people who are not represented through the political process. Administration works on the basis of systems. So what is the sense, really, of just correcting lots of individual errors? Why don't you just look at how well the underlying system is performing? And actually, when it comes to the challenge to the detained asylum fast track process, it had been reviewed by a select committee, but they can only make recommendations. They couldn't, they didn't have the expertise to look at it in detail. Well, courts do this all the time. I mean, courts can see how, higher court can see how lower courts are behaving and whether the system that they're operating is a fair one. So I sort of explain the rolling back by the Supreme Court. It's part of the broader politics, I think, of judicial review that's been going on. But I'm pretty certain that it will return at some future stage. Incidentally, ombudsmen in the UK have undertake, look at issues of systemic maladministration. So it's common in the ombudsman context. I think in Canada you have the Ontario ombudsman. In the UK we've got a variety of them. So I think the need for systemic review will return, I think. And it reflects the nature of administration itself, because public administration works on the basis of wider overarching systems.
Well, yeah, I mean, I was going to just to follow up again on this. Maybe one of the interesting things about that Supreme Court decision, and I'll pop a link in the chat in a moment to that decision that I'm talking about, and a comment I have on it. It's a decision which talks a lot about separation of powers and the rule of law, grand constitutional principles, which is often the case when matters get up to a Supreme Court, at the top of the hierarchy. Is there a danger, though, that at that point you kind of lose the wood for the trees, or you're looking, or you're just seeing the wood, actually, and you're not seeing the individual trees? And that's a bit of a problem, because at the lower levels, judicial review is all about intervening on a more or less case-by-case basis to say government got it seriously wrong in a particular area or with a particular policy. And maybe this case is an illustration of the dangers of the apex court getting involved and thinking about things in terms of fundamental constitutional principles, when really what you need is a greater understanding of the granularity of how administration operates in practice.
I'm absolutely certain that's correct, and there's a difference of perspectives from judges in top level courts who might decide like 100 cases a year from across the whole range, and it's not just public law, it's private law and many other areas of law. And if you compare them with judges on the front line who are seeing repeat cases time after time, they're going to have a different perspective in that regard. I'm sure that's the case. And the general principles of like separation of powers and parliamentary sovereignty and the rule of law, well, general principles don't decide particular cases. And the courts, I think it was a wrong turn. And actually the Supreme Court in the UK itself has undertaken systemic review in all but name when it's come to, for instance, fees for employees who want to go to employment tribunals and those fees being too high, and also things like oral hearings in parole boards hearings for prisoners. So I think it was I think probably the Supreme Court went a bit too far, and this type of judicial review will probably resurface at some stage. But judicial review decisions, the courts are in themselves, they're ruling on legality, but these decisions have significant impacts upon government and how government operates. So really the courts are part of the system, part of the wider system in a way, because they want government to act lawfully and fair and so on. And the courts can only really exert impact if their decisions affect how administration goes about itself. So that's why it's very interesting to look at the nature of the interventions by the courts and their consequences, and which are a direct result of the doctrines, the principles that they articulate. So this is important, and just also bear in mind again the context. If you're looking at immigration and also prisons, these are areas where the inequality between the state and the individual are probably at their most extreme. And government is not treating people always in a particularly fair manner, so yeah. So are there any?
No, thanks for that. Now back to the civil service. We have we've prompted we've managed to prompt a question thanks to Ephraim Beara for posing it. If the civil service could serve as a bulwark to challenge short-sighted decisions by elected officials, then what principles or standards should guide the civil service culture to effectively challenge politicians whilst not overreaching their authority?
Oh, that is a very good question. I think it's quite a difficult one. I think well, what one would be the set of values that are present in the UK in the Civil Service Code, things like impartiality and fairness and other values. I think other values are, well, what are the norms of good policy making? One would be to engage in evidence-based policy making, and to look at the evidence and not to work on the basis of groupthink and assumptions, and to have challenge, and whenever there's a meeting, to have someone who's always going to disagree. If everyone agrees in a meeting, then there's a risk of mistakes, of legitimate points of challenge being ignored. So evidence-based policy making, I think, is essential, and there's a real need for civil servants to have access to evidence base to inform their policy making, and there's quite a few academics in Canada and the UK who do this. So I think the other end, another factor would be to evaluate policies as they're being implemented and to monitor them. And a critical aspect in this regard really is about the data collection and analysis by government. Government is very often very bad at collecting data about how its policies are actually implementing, and also it's certainly quite bad in the UK at evaluating policy. And this is actually this is like the law being administered in practice. So I think those are some of the things I would highlight. I mean, certainly the Windrush scandal was a real failure and we talk about the need for government to have institutional memory, and what a failure like that really illustrates. It's not institutional memory by government, it's like institutional amnesia, it's like organizational forgetting. And without that type of memory and looking at what's happened in the past, these mistakes will happen. But ultimately, ministers decide, and this is just part of like the inherent. I mean, is that a good thing? It can be a good thing. It can also be, dysfunctional. I don't really know how we can easily eradicate this entirely from a liberal democracy, because some ministers can be very forthright, and they've got a clear view, clear agenda that they want to pursue, and civil servants can advise, but ultimately civil servants don't decide. And so I do recognize it's just an intractable problem. I think it's got to be like learning from mistakes as they happen.
Well, thank you for grappling with that intractable problem. I agree that it's very difficult, and it's very difficult to instill the culture that's it's very difficult to instill any culture in a large and complex organization, but getting the mix right between fearless commitment to civil service values, but also or to long-term social values, but also yielding to the minister's view of what policy requires in the moment is very difficult. I wonder, could I just take you back a little bit in terms of, you've certainly convinced me, like perhaps I didn't need that much convincing, or I'd like to think I didn't need that much convincing. You've convinced me that it is really valuable to look at the innards of a particular government department, take a particular area of policy and really strip it down, see how it is implemented, what the institutional choices are, the influence of institutional structures, and so on. What are the challenges for someone researching in an area like that, or someone who wants to do a research project like that? I don't want to look at the courts anymore. I want to drill down into a particular area. What would you say about the challenges and how a researcher might equip themselves to meet them?
That's a really good question, and it's a very important one. I think what you've got to do first of all is you've got to choose an area of government or a policy problem that interests you. Go and look out in the world, where is there a problem that is, or an issue that interests you and you want to devote time looking to. So I would start on that basis, and then, well, you've got to find out about it. So, what does a government department or public body, what does it actually do? What are the challenges that anyone working at that government department, what are the challenges that, they would face, and the difficulties? And I found good sources of information to be, the media, parliamentary debates, hearings before committees in Parliament, and all of the evidence where committees ask questions of officials and stakeholders, and going through all of that evidence, I found it quite invaluable. Ideally, it would be great for a researcher to spend time within the government department or public body. That's not always possible, because some government departments are defensive, and certainly the immigration department in the UK is very defensive. So look at other sources of information, so other reports, evidence transcripts and things like that, And actually, like there's I worked inside the Home Office about over 20 years ago. I worked there for a few months, and actually there's not really that much you can't find out from the outside. I mean, it's pretty, what you think, if you look at a government department, you think, oh, it's not very good, or that they make mistakes. Well, that's probably almost certainly the correct, and it's true. So what officials tend to be very reluctant to divulge is like all of like the personal sensitive information about individuals. But well, you're not interested in that really. If you're looking at government, you're looking at, well, you know, you're not looking into like the real minutiae necessarily, but just the overall picture, and you know how that government body, how it makes decisions and the processes. And you know, when you're looking at, you know, a government body that makes like literally millions of decisions per year, you can look at the general procedure, the general run of things. So I accessed a wider range of sources and any other like oversight or accountability bodies. So particularly in the UK, there's like a particular inspectorate that oversees immigration functions, and all of its reports are available. And as I've said, oral evidence given before parliamentary committees, that was very important. So I had this challenge before I did this project. I thought, well, I don't really know what's going on. You know, I'm standing on the outside, but you know, this is a large organization. It's complex. I can't understand it. Well, you don't need to understand every single thing, because no one could, because it's such a large enterprise. But what you can do is, you know, use what information you can access and use that, and almost certainly it will give you a reasonably good picture, quite a good picture actually, of what the government department is doing and what it isn't doing. And the other point I would highlight is, I'm sure you've got something similar in Canada. So in the UK, you can make freedom of information requests to government departments. And I did a number of those and got internal documents and stuff like that, which
I think you'd find that the general commitment to disclosure in the UK, believe it or not, is much much stronger than it is in Canada. You can certainly make FOI requests in Canada. Good luck getting an answer.
Right, I didn't know that. I think the other thing from my experience is doing freedom of information requests and finding what issues government does not have information on. So if it doesn't have information on a certain topic, then perhaps it's just like a low priority, or, you know, it's quite interesting what government does know, but also what it does not know. And all of that type of stuff, it really brought home to me the importance of information, because government systems work on the basis not of personal contact, but on collecting information about how the whole system works. And so I would try all of those things. I mean, some other public bodies are more open and accessible. And I know some researchers, also in Canada, they've spent time doing, you know, direct empirical field work within public bodies. And of course, you've got a federal structure in Canada. So if you can't do it if you don't get any access in one area, then you can go and try elsewhere.
You literally have a dozen or more options. So Aisling Ryan, from my alma mater, University College Cork, the most beautiful university campus in Ireland, at the very least, perhaps in the wider world. She asks, in light of the wider move towards plurality of research methods in administrative law, how can we attribute weight to different ways of knowing about administrative law? Or do we need to? and she says this question is basically about the relationship between doctrinal orthodoxy and empirical methods. That's an interesting question about how do you weigh the value, I guess, of different ways of looking at administration.
Well, I think it depends on your research goals and aims. I mean, both of those methods are, completely acceptable, and they're complementary. They shed different light on the same topic in a way. I mean, both of them have got their advantages, disadvantages. Ultimately, I think it's a question of academic judgment and what explanation or what theories are most convincing, and how you use the data analyzed. So Paul, your book on the values in judicial review and how it explains judicial review, I think that's a really convincing explanation actually of the different values that judges refer to when they explain legal doctrines. I think it's really convincing, and it's a good explanation. Someone else could approach judicial review and look at numbers of cases and how they get filtered in the system and out of the system and come up with theories. I think both of those methods are entirely valid. So ultimately, as researchers, we've got choices to make about how we use our time and what data there is, and whether, how to collect more data if you need new data, and the time involved in that. But ultimately, I think it is just a judgment call for you. And the other point is, with being a researcher, you've just got to give things a go and not prejudge the outcome. And you've got to be prepared to say, oh, I tried to do this and it didn't work. Right, okay, next time I'll try it in a bit of a different way. Because, if you don't try to do something new, if you're uncertain of whether it's going to be successful, well, just give it a go and see what comes of it. And don't come to your conclusions before you've actually, gone through that whole research process of collecting data and looking through it and analyzing it and all of that type of stuff.
When I was educated, no. When I was educated by the Christian Brothers in Ireland, we were often told the man who never made a mistake never made anything. And that's good advice. And in academic work, I mean, I guess sometimes people, they see the books and the articles, the finished product. They don't see what's on the cutting room floor, right? Which is often even more voluminous. So don't despair, folks. My colleague Yves Le Boutillier, who's an expert in Canadian immigration law, incidentally, as a kind of an illustration of just how complex this area of law is, Yves and another colleague, Delphine Nakache, set out to do a book on Canadian immigration, refugee, and citizenship law, which are that's the government department, Immigration, Refugees, and Citizenship Canada, and it quickly turned into a 3-volume project because the material is just so vast, so dynamic, and so fast changing. Anyway, that's by the by. Eve asks whether you were able to look at the criteria for the exercise of discretion that are not explicitly addressed either in legislative or regulatory provisions. The example he has is a decision to prepare a report about whether a hearing should take place to determine if an individual should be declared inadmissible, something that happens in Canada. But I guess the broader question is, discretion once the law and regulations run out, how does that work? How's that structured? How's it controlled?
That's a question that many people who've researched discretion have encountered, and it's very nebulous, because ultimately you've got one person's judgment, and who if you've got any decision-making process, yes, you've got criteria, you've got the the wider institutional forces that impact on the decision-making process? Do you have hearings, or do you just decide on the paper? What are the political pressures? So, you know, in immigration in the UK, the common complaint has been there's a culture of disbelief. And that's very contested. But I think and you can interview, you know, you could try to interview decision makers, but can they themselves articulate the types of factors that they take into account? And also bear in mind that each of us, we're all influenced by, you know, unconscious biases and cognitive biases. There's a lot of those in play. So, you know, it is a very nebulous thing to actually get a handle on. But nonetheless, I think you'd have to, I think you'd have to take a sample of decisions if you could do that. And do interviews with decision makers, look for patterns in their decisions and try and come up with theories and try and interpret, you know, those theories. I know there's been a lot of research in Canada about inconsistency in refugee status determinations and stuff like that. That's one area that I've, you know, getting the actual like hard data on that's something I've not been able to achieve. I would like to. So I think it is nebulous, and you've got to look at the wide range of factors. So for instance, you know, the decision to prepare a report regarding whether a hearing should take place, well, to what extent are like efficiency values and time and money, to what extent do they come in to that decision? Because that would depend upon caseload and resourcing and things like that. So yeah, I think that's quite an interesting one to explore. I'd be tempted to like try and, you know, speak to decision makers.
All right. I don't see any more questions, and I'm inclined, Robert, to let you enjoy the rest of your afternoon. I'm playing around with my Zoom here to see if I can't share the cover of your book, so people can see it in all its glory. The book is called Administrative Law in Action. Immigration Administration, published by Hart, as so many excellent law books are. And there it is. Robert is Professor of Public Law at the University of Manchester, and this really is a remarkable book and a real resource for anyone who's interested in judicial review, but also the inside of an administrative agency, how policy is actually made. Robert, it was a pleasure to talk to you, as it always is. Thanks for being so generous with your time, and thanks a lot. That was a fascinating and enlightening discussion, and it's a very thought-provoking, interesting, and important book.
Thank you very much, Paul.
Until next time, see you all, folks. Last event in the series in 2 weeks with Peter Conti Brown talking about central banks, which unfortunately is a is a hot topic again. Robert, thanks a lot. Always good to see you.
Thank you. Thanks.